Let me respond to the last submission made. First is, I think this is an attempt to revisit the decision that has already been made by this court as to whether a state can or cannot be charged in this court. And on this, there has been a clear ruling already. As regards the question of appearance, that they have not appeared, not submitted to jurisdiction, this has also been addressed in the written brief. And I read the last page of the written arguments of the amicus defense team. It says very clearly, the State of Israel has not entered appearance in these proceedings. By inference, it has therefore not submitted to the jurisdiction of this tribunal, and goes on to argue that therefore, for that reason, it should not be impleaded, and no proceedings can go against the State of Israel. So the first point I make is this point has been decided upon by this court as by way of a preliminary objection and cannot now be raised. However, there are equally good reasons, and I shall repeat them. Some of them were stated. The essence of the matter is that unless they submit to jurisdiction with regard to genocide, then no criminal liability attaches. The question, therefore, is there or is there not an obligation in international law for parties to adhere to international law, international customary law, including the conventions that are an expression of those laws, for example, the Genocide Convention. Now, on that point, before I deal with that point, just to say that the fact that nobody has been charged, right, in circumstances that have been outlined by counsel, does not mean, therefore, that obligation does not exist. The fact that, for example, Bush and Blair have not been charged does not mean, therefore, the President of the United States cannot be charged. That is not the point. That is a weakness of the system and not its strength. And this is why there is a People's Tribunal to supplement the inadequacy and the lack of gumption on the part of the international process to charge them. They should be charged. In fact, our whole point will be, if we get a genocide conviction, then we are going to move on the basis of universal jurisdiction to have some states or even the International Criminal Court to exercise that jurisdiction. So that is the point. Now, as far as whether or not, so the question is whether there's erga omnes. Is there an obligation or not? Because if there is an obligation, then there can be found some place, a tribunal to decide this particular matter. Because the question is there a basis in international criminal law to charge? That's the point. And the opinion, the decision of the International Court of Justice in the case of Bosnia-Herzegovina, which I cited earlier, is quite conclusive of the matter in coming to this conclusion that states have an obligation and can be charged. Now, what the respondent contended, that of course was a matter that was raised between states. It was Bosnia-Herzegovina against Montenegro and so on. Alright? And the respondent had in fact argued, respondent was Montenegro and Serbia and Montenegro. They had in fact argued that there was no obligation. So if this makes a very clear point, very clearly to direct our mind very clearly to the question of A, whether states have obligation in international law, secondly, whether they can be charged, and thirdly, whether they can, when they are charged, claim immunity or no immunity. So I'll just address these questions very briefly.
Yeah, I don't think Dr. Matthews ever said that there is no obligation. I think what he was saying is to charge them in criminal law, you need their consent. Without consent, there are no precedents. So what really is necessary here is for the prosecution to point out some precedents if there are any.
Well, I mean, the point is that the first point I made is that the fact that there is no precedent does not mean that therefore that is a weakness of the system, not its strength, not indicated. And secondly, the point is that if parties have, Israel is a party to the Genocide Convention, and if they have, if they recognize that this is a crime that this is a convention that imposes obligations upon them as a state, as well as upon its citizens, then the question of consent to agree to consent to be charged for genocide is absurd. No state would consent, no murderer would consent to being charged. So what it would mean is to scuttle completely the whole thrust and purpose of the obligation that is set out in the Genocide Convention. Because if there is an obligation for you to ensure you yourself do not commit genocide, and that is very clearly set out in the Bosnia-Herzegovina judgment, as well as to make sure that people within your jurisdiction do not commit genocide, then this is a sure way of scuttling the whole purpose of the Genocide Convention itself. It requires consent.
Sadly, the law, domestic law, international law does know of sanctionless duties. It is a concept of sanctionless duties. Duties can exist. They may not be enforceable. I'm with you on this point that the whole idea of obligation is that there must be enforcement.
Yes.
I think what Dr. Matthews was saying is at the moment there is no such thing as international law.
No, but if the declaratory if the judgment of the ICJ in Bosnia in the Herzegovina case says that it does not, if the convention does not apply merely to individuals, but as well as to states, and that includes the punishment section of the Genocide Convention, then what it in fact is saying is that the convention as a whole applies to both states and individuals within states.
Yes, I think Dr. Matthews used the word states have a right. States have a right, and at that moment I didn't get to intervene. Whenever there are rights, there are also some duties correlated with it in the jurisprudence. So,
in my respectful submission, I think the Bosnia-Herzegovina case is conclusive to the matter, because they do say that it would be paradoxical if a contracting party, having agreed and confirmed, because the Genocide Convention confirms that it has always been an offense, a crime to genocide has always been a crime. It's been recognized. Then to say that therefore they are under no obligation unless they consent to be charged. And this is only has to be stated to note how absurd it is that a person who is accused of genocide would then say, yes, I consent to being charged. And there is no immunity either. I submitted in my submission on the preliminary point, where I pointed to various paragraphs in the case of Jones, and I referred to the judgment of Lord Tom Bingham, in which he says that when it comes to criminal proceedings falling squarely within the universal criminal jurisdiction, then international law could not, without absurdity, require criminal jurisdiction to be assumed and exercised where the Torture Convention conditions were satisfied, and at the same time require immunity to be granted to those properly charged. So, if you read this, and you read the Bosnia decision, where it says it's paradoxical, if states themselves are not obligated under the Genocide Convention, if you marry these two together, then it becomes very clear that A, that they can be charged, and B, when they are charged, they cannot claim immunity. So that actually deals with the question of consent, because immunity is always sought by those who say that you should not have charged me in the first place. That is also relates somewhat, points somewhat in the direction of whether or not there should or should not be consent, because immunity is always sought by a state and say, you can charge me, whether in civil or in criminal jurisprudence. Why? Because I have immunity, I should be protected. And so they have not consented. That is the point, they have not consented. That's why immunity. And if this pronouncement makes very clear, the case that in fact was provided by the amicus, that you cannot claim immunity in respect of criminal, in civil you can, in criminal you cannot, makes it very clear, then the question of consent is academic. And finally, on the point of the fact that you are charging the whole state, what is in fact always charged? When you charge against a state, you never charge the whole state, all the peoples composed in the state. But essentially what you're doing is you are charging the state for its practices and policies. And no inhabitants of the entire state are privy to the state policies and practices. And we heard Professor Ilan Pape talk about the fact that what is in fact being condemned is state policies and practices of those in power. So this is how it's always understood. Otherwise, you need, even in a corporation, you'll need, I think the Judge Shah Faruqi and Judge John Philpott, with respect, said that means even when you charge this argument, if extended, would lead to absurd results, especially in criminal jurisprudence, because you cannot charge a corporation. Why? Because they have shareholders. They have hundreds, maybe thousands of shareholders. And so if you condemn the corporation and hold them criminally liable, you are also condemning every shareholder in that corporation. If you use that analogy, when you charge a state for genocide, you are condemning its state policies and practices. So you are looking at the governing body that governs the corporation or the state. And this is the way, this is the direction it should go. Otherwise, it is empty rhetoric to suggest the Genocide Convention confirms since 1948, in response to the Nazi crimes, that there should be a convention to deal with this. Having declared that in 1948, then to say that anyone who commits a present-day Holocaust is immune simply doesn't make sense. Thank you.
Your Honors, I have 5 very brief points to address, and I will conclude. Firstly, the contention raised by the prosecution concerning universal jurisdiction. I am aware of the fact that in the previous session, Bush and Blair were indicted by this tribunal. The prosecution appears to be confusing jurisdiction over an individual with jurisdiction over a state.
Sorry, just so that you don't mischaracterize my... I'm not saying that, I'm just saying that that was on the question of precedent and no precedent, not on the question of individuals or states. Thank you.
However, as I've stated previously, individual criminal liability is a completely separate issue to the responsibility of states. Universal jurisdiction, as I've already argued, allows for the exercise of jurisdiction over individuals. The issue in the present case concerning charge 4 is that the prosecution has charged the state of Israel, not individuals within the state of Israel, not agents, actors, or organs of the state of Israel, but the charge reads, the Kuala Lumpur War Crimes Commission against the state of Israel. Charge 3, the Kuala Lumpur War Crimes Commission against Amos Uran. This is the distinction in regards to charge 4. Secondly, I am not arguing that obligations of states do not exist. Erga omnes do exist. When they are violated by individuals under contemporary international law. Individuals may be held criminally liable. All right. In regards to the responsibility of the state, this is a matter of state responsibility rather than individual criminal responsibility. And as I noted before, state responsibility can be invoked. Jurisdiction can be exercised, but only on the basis of the state consenting to the proceedings. All right. Additionally, in regards to the reference to the genocide case, the court did note that it was paradoxical. However, the question concerning the court's jurisdiction was not based upon where the court thought the law should go. All right, what the law should state, what the law should be. The jurisdiction of the court was based upon the fact that under Article 9 of the Genocide Convention, the International Court of Justice was allowed to exercise its jurisdiction over disputes arising between two parties to the convention. All right. There was no question concerning the court's jurisdiction raised per se. Fourthly, number 5, to sum up. The prosecution's argument rests on what the law should be, rather than what the law is. I'm aware of the fact that there are arguments that exist that the law should evolve. It should go further than it has. But under international law, the law that exists at the time is the law which must be applied. And if there are no further questions.
I have 2 questions. One, you said the burden of proof for genocide is almost certainty. Well, I don't see that. The burden of proof is beyond all reasonable doubt. And you say the burden is different for genocide than for other crimes. I don't see that. Clarify.
Your Honor, when I made the submission, I seem to recall stating that I did explicitly state, actually, beyond reasonable doubt was the threshold. So, beyond reasonable doubt and virtual certainty between those two limits is the required burden of proof for crime for the legitimate charge of genocide.
How do you see the Nuremberg creation of the obligation on a state, as was argued in the defense opposition to your preliminary motions? That the obligations not only apply to individuals but to states. Mr. Singh can clarify that. He argued it. Mr. Gurdio.
Yes, indeed, he argued, and that was a criminal tribunal. In the criminal tribunal, Nuremberg stated very clearly that there's a duality of responsibility. There's a responsibility of states as well as for individuals. That's a Nuremberg criminal jurisdiction, and that is in fact the foundation of genocide. I can read the express point message.
Your Honor, if I may, the issue that arose at the Nuremberg trials, they did exercise jurisdiction over crimes amounting to genocide. The Genocide Convention in and of itself is reflective of this point. In preamble as well as Article 1, it specifically denotes in the Genocide Convention that the crime of genocide is and has been a violation of international law. All right, that was specifically that portion was specifically included to denote the fact that the Genocide Convention reflected existing law as well as law which had been recognized as customary previous to. In the case of Nuremberg, the Nuremberg Tribunal, in and of itself, actually provided for the prosecution of collective entities. However, the actual trial, the trial chambers, the judges themselves, refused to rule, all right, on the basis of collective punishment, because they said irrespective of a person's membership in an organization or an organ, they still had to prove individual liability. You cannot sit down and say you have criminal liability solely based upon your membership in an organization. Individual criminal liability, by definition, must apply to the acts or omissions of the individual charged. All right, not the acts or omissions of the organization or entity to which they are a member. That was the precedent established in the Nuremberg trials. That was the precedent established in the Nuremberg trials.
Can I just respond to that point? That point was expressly repudiated in the Bosnia-Herzegovina case, where it was argued that before states can have obligations, you must have a conviction. That means you must charge an individual in that particular state who is responsible for the acts of the state. But this was rejected in Bosnia-Herzegovina. And it said the conviction there was no requirement for a prior conviction of the individual before state liability attaches.
To clarify my comments, Your Honors, I do not believe I have at any time indicated that an individual must be charged prior to a state requiring responsibility for conduct or actions. I have not argued this. Prosecution is correct in his assessment that this issue was raised in the former Yugoslavia. What I have just presented concerns the international military trials at Nuremberg. In fact, the international military tribunals at Nuremberg, and the fact that the judges, based upon existing international law at the time of tribunals, all right, again, the prohibition against collective punishment is customary international law in nature. You can find references to it in the Geneva Conventions 1 through 4, additional protocols, and ICCPR. However, I was not asserting that individual criminal responsibility must be found prior to state responsibility.
Well, this is our submission in response to the case to answer, and so the court will have to decide whether or not the defense has a case to answer. And if they have the case to answer, then there must be a submission. Then they got to decide whether, so the process is governed by Article 28 at page 43. So first there has to be a ruling on whether or not they have a case to answer. If they have a case to answer, then they have to give their submissions. Either they have to call their witnesses, or in the absence of the witnesses, then make their submissions, and then we will respond. And they have, of course, the final say. So now it is for this court to rule on whether there is or is not a case to answer.
Can I say something? Can I say something? I'm with you. Except that I have this problem. We have been listening to your 10 witnesses. I thought I'm still waiting for your closing submission.
Yes, except that if you look at Article 28, page 43 of the Charter, it says Article 28, I read with your kind leave. The accused or his counsel or the amicus curiae, as the case may be, may submit no case to answer at the conclusion of the case of the prosecution team, which is exactly what they've done. Article 29, in the event the tribunal decides, so there's going to be a decision by the tribunal, that there is a prima facie case against the accused, the tribunal shall proceed to receive evidence from the accused or his witnesses where present and available, so witnesses, if they have any, or in absence, that means of the witnesses or the accused, to hear submissions from the amicus curiae. And then it says the prosecution team shall thereafter close the case, followed by a reply from the accused.
Yeah, I'm with you. I am guided by what we have practiced in the past in our various cases before us. And if I remember correctly, at the end of each of those cases, when you have completed submitting your witnesses and your documentary evidence, you end up by your closing submission. So I've been waiting for your closing submission because if I remember correctly, we had your closing submission and then finally we cross the bridge is whether there is a defense to be answered. Then we get to your final submission, and then in those past cases, you told us that you have adopted your earlier submissions, both your side and defense. So I was here waiting actually after I finished listening to all your witnesses and your documentary evidence and your scribe. Where is your closing submission? I may be wrong, but this is what I have, this problem that I have.
I'm quite happy to give my submissions, and then and have no submission. I mean, this will be the final submission, as it were. But I'm in your hands completely. I'm just following the rules, but I do appreciate the.
Except that never start with the time of the day is what you pass the lunch.
Yes. But well, I'm happy. I will only be making one submission. So whether I make it, I'm in your hands as to when I make it. But I thought at least there should be, before we run our whole gamut of the arguments, at least there should be a ruling whether there is a case to answer or not. If there is a case to answer, if it is desired that I proceed first, I'm quite happy to do that.
I think our difficulty is before we even decide if there is a case to answer or not, we will have to have your closing submission at the end of the prosecutor's case. So that we have done in the past.
I'm quite happy with that. If that is the
Can we do it? Can we do it after the lunch break?
Yes. Yes. But that means the question of whether there is a case to answer is
We have not made up our mind yet.
Deferred until after my submission.
Yes. I'm following past practice.
I'm quite happy with that, except that it's the charter says something quite different. But I'm happy to do it either way.
I think what it amounts to is we have a pile of documentary evidence, a lot of documents, and you could run us through them as a way of presenting the documentary evidence as evidence, since we've seen the oral witnesses. And then we can deliberate in general with respect to the no case to answer, and come back and hear the defense submissions, and then you can confirm.
I think I'm quite happy with that course, and I can commence anytime.
I believe we will. I will only do. I believe I only need to do the closing for the defense if a case to answer has been decided by the tribunal. So there must be a decision first before that bridge.
I think we might as well go for lunch. It's at the right time. And otherwise, you'll have more worries in your head. So I suggest